is my first appearance here tonight. I hope you don't mind if I stand. I kind of want to see if I can get everyone to hear. Before I started, I did want to ask for some leniency from your 2-minute rule. It is my first time. I do intend to keep it quick.
I would just want to, we have in the past given it time for experts. People have been hired representing the group as a whole. I mean, so
understood.
I think within reason, that's what we have been practice to do.
I promise to keep it to 5 to 10 minutes at most.
No. It's going to be less than that. I'm sorry, too.
The name of the firm?
Zarin and Steinmetz. I can spell it if you'd like.
Sure, please.
Zarin is Z-A-R-I-N. Steinmetz
I
is,
got it.
oh, you got it.
Yeah, we got the
Sorry.
letters. You're Zachary?
Yep.
All right, continue.
Sure. So just a little bit of background on me and my firm. We specialize in land use and environmental law. We've represented municipalities. We've sat where you guys sit. We represent planning boards, zoning boards. We also represent property developers. On occasion, we also represent opposition to property development. We do so when we think it's appropriate, and this is one of those cases. Tonight we're here on behalf of Safe Craryville. I'm sure that you received our letters. My goal here tonight is not to repeat everything in those letters, it's to just key in on a few points. We do understand that this is a sensitive project. Obviously, there are many people here. This public hearing's been going on for a while, so I'll get right to it and try to just get the discourse. First point that we wanted to make sure was made clear tonight was that we believe the special permit that was originally granted by the ZBA has expired. As a result, this application should be back in front of the ZBA within the Copake zoning code. Special permits that have not been built upon in 1 year expire. Even if it had not expired, the ZBA would still need to consider all of the changes to the application and the new potential environmental impacts that it had not originally evaluated. So even if you wanted to have the same special permit, it should still go back for further review under secret. Just a little on the neg deck. The neg deck that was issued, I apologize, I'm using shorthand, negative declaration that was issued under secret.
We know.
We speak land use mostly.
Got it. That was issued before the ZBA knew about the aquifer. Respectfully, the ZBA should reevaluate the plan, knowing that the aquifer is something that's potentially impacted by this application. Given to the changes that was made to the application since the neg deck was issued, the applicant will either need to have that negative declaration rescinded or restart the secret process. If they simply reapply for the special permit, it would restart anyway, so that's probably what's best given the other flaws in the original secret proceedings. Just as to those briefly, we'd seen no written record from the ZBA that demonstrates that it actually established itself as lead agency properly, or that it actually completed the secret process. Based on the ZBA's November 2016 minutes, we don't believe that the ZBA has circulated its intent to be lead agency. And we also have not seen any record demonstrating that the ZBA filed and distributed the neg deck. Without that, that means the neg deck isn't complete, secret review isn't complete, and that all of this is being done prematurely. Ultimately, your board can't rely on a negative declaration that was issued incorrectly or that wasn't complete. Even if the ZBA had taken the correct procedural steps, it failed to take the requisite hard look under SECRA. It's probably fair to say that the applicant either provided incomplete information or misled the ZBA at the outset by not providing information about the aquifer. But ultimately, now that the ZBA knows about the aquifer, it should conduct a full environmental review with that in mind. As I'm sure has been made clear, gas stations do pose a serious pollution threat. I know that this group's hydrogeologist, Paul Rubin, has submitted letters explaining the potential impacts to the aquifer and how pollutants may enter drinking water and wetlands through that aquifer. The last thing are just two quick procedural things. One is I wanted to let the board know, and town's attorney know, that we will be submitting a Freedom of Information Law request just about documentation related to this application and also about the Copake zoning code. I'm sure that your counsel will advise you as to proper compliance under New York Public Officers Law, but we do look forward to reviewing a complete file. Obviously, we were just recently retained. And just as to the public hearings, I've been informed that at prior meetings, the board has told the public that it would be closing the public hearing for the night and that it would then continue discussion of the application after that. We would just ask that if an item is open for public hearing, it remain open, and that if there's a public hearing, everyone that is interested should have an opportunity to hear what's going on. Ultimately, we don't want there to be an issue of violation of open meetings law or anything like that. So that's really all I have for tonight. I do thank you for your time and for giving me some extra time on the 2-minute rule. We look forward to working with you guys going forward.
All right, thank you.